A very warm welcome to all our delegates today, and thank you for joining us for the second part in the series of our cryptocurrencies webinars. My name is Lucinda Brown, and I'm a partner in BDB Pitmans, specialising in trusts and estates disputes. It's fantastic to see so many of you here again today. We had a very thought-provoking session, I thought, last week in part one, focusing on key tax and trust issues for trustees and their professional advisors. The focus of today's session is geared more towards my area of work, which is contentious trusts, and we'll talk around where claims against trusts holding cryptocurrencies might arise. We'll also be looking at reputational concerns for trustees involved with crypto and some of the hacks and scams in relation to crypto to be aware of and to guard against. I'm once again joined by an experienced panel of speakers who are keen to share with you their thoughts on this developing area. Andreas Kistler is a partner in the trusts and private wealth and dispute resolution teams at Carey, Olsen in Jersey, and has extensive experience of court proceedings concerning Jersey trusts. He appears frequently in the Jersey courts in such matters. He also advises in a broader range of disputes, including fraud and asset tracing, corporate and investment fund disputes, and general commercial litigation. Although Jersey has not yet had any reported decisions concerning crypto assets, Andreas has some views on the risks that trustees are exposed to when investing in crypto and how those might be addressed, and we look forward to hearing from Andreas. I'm also joined by John Darnton, a consultant in the BDB Pitmans litigation team, who has a specific focus on family law and trust disputes. John has decades of experience of family court work and will address how cryptocurrencies are affecting divorce applications at present. Virginia Szepietowski is a solicitor in the BDB Pitmans restructuring and insolvency team with expertise in cryptocurrency and blockchain. And Stuart Thomson heads the firm's specialist public affairs and communications consultancy. He has been advising clients on all aspects of their public affairs strategies, including political and corporate communications and reputation management for over 20 years. He is a CIPR chartered PR practitioner, the author of several books, and last year won the Vulio's Online Influencer of the Year award in the current affairs category. The webinar, as before, will be recorded and will be made available on our YouTube channel in the coming days. If you have any questions you'd like to put to our panel, please enter them into the Q&A function, and I will come to those at the end of the discussion. So if I could kick off, please, with you, Andreas, and ask you, what risks should trustees be thinking about, do you think, if they invest in crypto assets?
Yes, absolutely. And hello, everyone. So for those of you who attended the first session, you'll have heard from my colleague Chris Duncan about the particular challenges for trustees in the context of maintaining safe custody of the crypto assets. And in particular, anecdotally, at least from my colleague who has advised on a number of such investments by trustees, trustees are hesitant to the point of being frankly unwilling to hold crypto assets directly in their own custody. And there are obvious risks if a trustee does maintain control of the private key that you need in order to deal with crypto assets. In particular, they could lose that private key, and we've heard that can, at least for certain crypto assets, mean losing access to the asset entirely. You can be susceptible to hacks where the private key could be stolen by nefarious actors. You can have other data leaks. We've seen that has affected various trust companies. And then finally, there's always the risk of employee theft, a rogue actor within the business. So if the trustee is not willing to hold the private key, it might be tempted to allow the settlor, who has encouraged the trustee to make that investment in crypto in the first place, to maintain control of the private key on the basis that he or she might well be making some investments on the trustee's behalf, given that they know what they're doing. That in itself is also very risky. So of course, one of the primary duties of a trustee is to maintain control of the trust assets and to be able to steward them. If you have them in the possession of a settlor, and if the trustee then falls out with that settlor and the settlor takes the view that they'd rather prefer to have the currency in their own hands rather than in the hands of their trustee, you might well find you don't have a trust asset at all anymore. So for these reasons, a trustee will generally far prefer to engage a third-party custodian to maintain control of the crypto asset. And there are various technologies and approaches to how custody is maintained. Not all of these are necessarily high tech. Some of these can be as simple as having the key printed and put in a secure safe or safe deposit box, and we'd call that an offline arrangement. The problem with that, of course, is that you need someone at your third-party custodian to open the box and give you the code when you need to transact with the crypto. And if you're being told that there's an urgency to deal with the crypto, that's not always going to be sufficient. If you need to transact on a weekend or after hours, you could be subject to fluctuations in the value of your asset in the meantime. Alternatively, you can have it online, and then you need to be confident that the security arrangements and the security arrangements around how you access the private key and the crypto asset are robust. It's easy to foresee claims against trustees in this regard, either from maintaining insufficient security or from being too slow to transact with crypto assets where they are in a period of volatility. Aside from that core custody issue, the issues that affect crypto assets are probably quite similar to various other high-risk, volatile assets that trustees might be encouraged to invest into from time to time. There are additional risks, of course, in the area of lack of regulation and the fact that this is all being done online, where you've got anonymity and the risk of criminal actors involved. So in terms of what the particular duties of the trustee are faced with these risks, under the Trust Jersey law, so we've got to speak specifically about Jersey Trust because that's where my expertise lies. The trustee is under duties to preserve and enhance the trust fund. Those can be excluded by the terms of the trust. It's also under a duty to exercise reasonable skill and care, and that's a duty that cannot be excluded under the terms of the trust. So if we look at what the duties to undertake reasonable skill and care involve and what they require of a trustee, they're certainly going to require the trustee to understand what it is it's investing in. So while it might be quite familiar with residential property and shares, investments, and the like, the novel nature of crypto assets are probably going to represent a relatively uncharted territory for many trustees. And in order to support an investment decision, they need to demonstrate that they at least know what they're dealing with and what the risks involved in it are, how much they should be investing, in what circumstances they might want to think about divesting that asset in order to protect the trust fund. And in this regard, of course, the nature of crypto assets can vary very significantly as between each other. I don't pretend to be an expert in the particular kinds of crypto assets that exist, but certainly you have the conventional cryptocurrencies that are well known, and the volatility is also well known around those assets. You have the advent of stablecoin, where the idea is that the cryptocurrency is pegged to the value of a fiat currency. Well, there you might seemingly have less volatility and less risk, but the question is whether that stable coin actually maintains sufficient reserves in order to maintain its pegged value to fiat currency. You have the highly publicized advent of non-fungible tokens, and the questions around whether that's simply a bubble or whether that's here to stay. And then one that my firm's been asked to advise Jersey trustees on is subscribing for future tokens. So where particular players in this market intend to launch a new token, perhaps to play on a gaming platform or similar, and they need seed capital in the form of fiat currency in order to fund that. And what you're doing is you're actually providing the working capital which they use to launch the currency. And if they're successful, you receive a number of tokens at a hopefully discounted value. Of course, if they're unsuccessful, they've spent your subscription and you get absolutely nothing. And so the risk in that sort of investment is very high as well. And all of those risks are very different, and the trustee needs to understand them. It brings in the usual considerations for a trustee of diversification and not having all their eggs in one basket, let alone a risky basket. And one that my colleague has related to me is that apparently on various crypto exchanges, there are readily available options to leverage your investment in cryptocurrency so that you can borrow and increase the face value of your investment. And that, of course, multiplies your opportunities for making losses as well. So in terms of how to further minimize the risk for trustees in this situation, the Jersey Trust law provides for a trustee to be able to appoint a manager to manage the trust assets. And the general rubric there is that if the trustee exercises reasonable skill and care in selecting the manager, and they make an appropriate appointment of manager, then the trustee is not then liable if the manager defaults or makes a negligent investment. They've discharged their duty by appointing a proper manager. But that's not the panacea which it might seem to be, because of course the trustee is also responsible for setting the investment mandate for that manager. And if something goes wrong with the investment portfolio, you can bet your bottom dollar that they will criticize the mandate that you gave to the manager. It might also be tempting to appoint the settlor, who's again keen on crypto and the one gunning for various investments, to appoint them as the manager. There you've got to be satisfied that they actually have some expertise rather than just a set of hunches into what they should be investing in. The next option, perhaps a more sophisticated option, is the Jersey rubric around settlor reserved powers and settlor directed trusts, where our Article 9A of our law allows you to draft a trust instrument. So this will be a new trust, not an existing one, whereby the settlor reserves the power to themselves to direct the investments that the trustee should make, and the trustee is then duty bound to act in accordance with those directions. And the Jersey law specifically provides that where a trustee complies with and acts in accordance with that exercise of power by the settlor, they don't act in breach of trust. But that hasn't yet been stress tested in any sort of really difficult case. And so you have to ask yourself, if a trustee is asked to stand by or even to facilitate and provide funds for an investment that the settlor has directed, which is very clearly high risk and likely to cause loss, is the trustee truly immunized in all circumstances from liability in that circumstance? You'd have to take very careful advice around that issue. Where you're reserving powers, you have to be careful for other reasons, of course. The risk that your trust could then look less like a trust to other parties, in particular creditors of the settlor who might want to try and get at the trust assets. If the powers are so extensive as to amount to ownership of the trust property, you might well be looking at the territory where a creditor could appoint a receiver over the settlor's powers and have them exercised for the creditor's benefit. So if you are going to go down the settlor reserve power route, you want to restrict those powers to the powers of investment and not powers of revocation and changes of trustees and other things like that. Even if the trust is valid under Jersey law, which it will be, because we specifically provide that reservation of powers won't undermine the validity of a Jersey trust, other jurisdictions looking at that, tax authorities and other jurisdictions, may see that quite differently. And we've seen that played out in cases like Pugachev and Webb and Webb in the Cook Islands. A further strategy, and these aren't necessarily mutually exclusive, you might do both in tandem, would be to hold crypto not at trust level, but at underlying company level, so that the investments are made by the directors of that company rather than the trustee themselves. There, as a starting point, the trustee would have the conventional duties to act as a prudent shareholder would under Bartlett and Barclays Bank, to monitor what's going on in the company and to take action if something is going wrong. And that action may involve changing the directors of the company so that it is no longer conducted in that way. It's possible, as we know, to exclude Bartlett duties in your trust instrument, so that the trustee has no obligation to intervene in the affairs of a company in the absence of awareness of fraud or dishonesty. So such a clause needs to be drafted with great care and attention. The most effective clauses provide not only that the trustee has no obligation, but indeed that it has no power to intervene in the affairs of the company in the absence of fraud or dishonesty being brought to its attention. A comprehensive Bartlett clause in that form appeared in the Hong Kong case of DBS and Zhang, a case concerning a Jersey law trust, and the anti-Bartlett clause there was upheld and the trustee was held not liable in the circumstances where the settlor, who was a director of the underlying company, had made highly risky and highly sophisticated investments in foreign exchange instruments, which led to catastrophic loss of many millions of pounds. So that case, that Zhang case, is likely to be influential on the Jersey courts, but there is always a word of caution. It's not binding on our courts, and I think that the risk that the case wouldn't be followed are increased in circumstances where, on the facts, the trustee is involved in approving the funding for the risky investments at underlying company level, where it has a director on the board of the underlying company, so it in fact has actual knowledge of what's going on, or where it, to take it to the crypto case, where the trustee retains as a co-signatory authority to deal with the crypto asset. So its approval is needed to transfer the crypto. In circumstances like that, or any other circumstance where the trustee has actual knowledge of what's going on, the Bartlett clause is potentially going to be ineffective.
Thank you. Do you think the public nature of the blockchain gives rise to any greater risk of claims by third parties?
I think potentially it does. So the starting point for this perhaps is the recognition in the New Zealand case and also the English case that crypto assets and cryptocurrencies can be property. And given that status, it ought to be possible for third parties, whatever their interest, to trace from their own proprietary claims that they might assert against the settlor or someone else from whom the property originated into the assets in the hands of a trustee, and to try and make some kind of claim against those assets. And that potential arises, to my mind, from the nature of the distributed ledger that is used for certainly some of the cryptocurrencies, which allows, provided that you know where the funds started, you can then trace through the blockchain, which is publicly available, to find out where the cryptocurrency has ended up. I was interested to read in preparing for this talk that criminal actors have found a way to try and obscure that trail. And apparently there are such things as mixers and tumblers, which allow criminals to take a block of tainted cryptocurrency, effectively chop it up, mix it with cryptocurrency from various legitimate sources, and then to withdraw funds from there with a much lower proportion of taint than they started. As interesting as that sounds, the greater the amount of cryptocurrency you're trying to launder in that sense, the harder it becomes. And technology is constantly evolving so that these tactics are becoming less effective. So I think that the traceability of crypto assets may well encourage tax authorities and justice authorities to try and follow the trail of where the currency has ended up, and that may well lead them into the hands of a trustee. That tracing exercise may also ultimately lead you to a custodian or to a crypto exchange who hold the asset for your wrongdoer. And there we're looking at the sort of conventional asset recovery measures that you might use of freezing orders and disclosure orders to obtain information and control of that currency. And you're having to go really to the jurisdiction where that currency is held by that third party to make those orders effective. And as a recent example, our BVI office has just obtained in the past few weeks its first injunction against a company holding cryptocurrency. And in particular, in the facts of that case, the funds have been diverted from the BVI company by its directors to their own wallets. And so fortunately, on the facts, our clients, the plaintiffs, had the originating addresses where the cryptocurrency had been held by the company. And so they were able to undertake this exercise of tracing through the blockchain to find where the currency had ended up, so they knew where to direct their injunction. But at a practical level, what they've told me is that the difficulty is, unlike a bank where you have an office, you have an address, you have an in-house legal department, you know where you direct your injunctions, that they freeze the account, you get control straight away. Where you're dealing with a crypto exchange, you usually don't have a telephone number, you've got some email address that you email, and of course they don't have a vast call center of people dealing with inquiries, so they aren't responsive. You have got absolutely no idea whether your injunction is actually being complied with or not. So the practical feedback they've given me is that you want to tee up in advance that the crypto exchange knows that you're coming and that they're going to help you as soon as you serve them with the injunction once you've got it.
Fantastic. Thank you very much. Must be the first sort of practical tips in relation to injunctions we've heard. Super. John, could I come to you now, please? And could you, I mean, from a matrimonial perspective, are there any particular risks or issues in relation to crypto that you're seeing emerge at present?
Thank you, Lucy, and good afternoon. I think we've all seen that one of the features of the pandemic has been that lawyers and other commentators have spent a lot of time writing articles and blogs, and therefore there's been quite a lot of publicity recently about the connection between cryptocurrency and divorce, the use of cryptocurrency to hide money, a form of asset protection. I suspect the reality is probably at the moment rather more prosaic, and that whilst cryptocurrency is commonplace, it's not yet mainstream in many of the divorces which are taking place in England. But I do think there's a danger, given some of the rather pejorative comments that surround this type of asset, that we could be moving into a territory where the holding of cryptocurrency is rather seen like the new Swiss bank account. At one time, many wives would come into my office convinced that their husband had a Swiss bank account based on his quarterly trips to Geneva or Zurich. And a lot of time and effort and money was spent trying to track that down. So I think we could have a similar situation with cryptocurrency, particularly where there's no an obvious trace to the asset in the first place. We know historically that certain prominent family division judges in England have made comments about the use of trusts, which have not always been particularly complimentary. And I think that trusts which hold cryptocurrency are perhaps subject to a double whammy. As long ago as 2003, in the case of JVC, Mr. Justice Coleridge condemned what he saw, the all too frequent practice of attempting to conceal resources behind a screen of offshore structures. And it went on to identify the huge cost implications that tended to flow in cases like that. And then the following year, a case which is well known to, or should be well known to some of the participants from Jersey, there was the case of Minwala, where Mr. Justice Singer went even further. He made the comment that no doubt the professional advisors and trustees of wealthy individuals wish honestly to strive to construct a network of interwoven trusts and companies able successfully to withstand the scrutiny of the Inland Revenue Services. But he then went on to be led by the nose by the wife's counsel, to almost find that the trust structure that the husband, Mr. Happy Minwala, was using was a sham, which in trust terms is a very strong point to make. But he did find that the husband never had the slightest intention of respecting even the formalities of a trust and corporate structures that had been set up. And I think one of the issues that we find in an international world is that people from some jurisdictions don't always respect the niceties of a common law trust and see the trust as being a somewhat different vehicle to what it actually is. Sadly, bad cases make bad law, but I think there is a real danger that somebody with a lot of money tied up in cryptocurrency, which is then placed into a trust during a marriage, is just going to be a real red flag.
Absolutely, thank you. And you touched on another aspect of this, which is, how do you know a spouse is holding crypto in the first place? How do you know whether it even exists, and how accessible is the crypto as a resource on divorce?
Well, indeed, Lucy, and I think this is one of the reasons why we start to get into the area of costs and legal costs becoming sometimes disproportionate to the value of the asset in dispute. We read of large, of the big players holding significant sums in cryptocurrency, but it may well be the case that somebody's just got a few £100 or a few £1,000 worth of cryptocurrency, and you don't want to spend tens of thousands of pounds trying to track that down. The standard procedure in England is obviously that you give full and frank disclosure initially by way of a form which attaches to it bank statements for a period of 12 months. Well, that may or may not be sufficient to allow you to track the source of cryptocurrency. You may not know what's happened to it beyond the fact it's money is left in the account on a certain date. But if you're looking at a situation where the currency was acquired outside of that 12-month period, you're in a different situation. And I think we are now thinking much more in terms of seeking orders in respect of people's hard drives, in particular their mobile phones, to try and not just understand what their text, emails and WhatsApp messages may say to their mistresses, but more whether they've got programs or apps on their machine that demonstrate or heavily suggest that they've been acquiring or dealing in cryptocurrency. And of course, there will be cases where there will be a strong belief that somebody has cryptocurrency, but a worry that as soon as they're tipped off to the fact you know they've got cryptocurrency, they can use the speed with which you can dispose of it to move the cryptocurrency around. And therefore, in addition to more complicated discovery orders intent on finding the information, we may be moving into a territory of injunctions specifically designed to try and freeze the use of the key. Now, given the different types of private keys you can have, it's going to be important to make sure that the injunction sought is specific to what you're actually trying to freeze. And then, of course, you get into the question of is that injunction actually going to bite against the key? Where is this thing you're trying to hold on to? We know that the English court feels it's able to make injunctions over assets which are outside of the jurisdiction. But whether or not those are enforceable is a different matter. Andreas will be able to confirm that the Jersey court is prepared in certain circumstances to make orders to assist, but they're not going to do that at the drop of a hat, and they're going to need more than just an English judge throwing his toys out of the pram. Moving on, I think it's probably been decided beyond any further argument that cryptocurrency constitutes property for the purposes of the English legislation, and therefore, in theory and in practice, there's no reason why an English family judge cannot make an order directing that cryptocurrency is transferred from one spouse to another on divorce. We'll probably return later to the difficulties of actually enforcing that order. It could well turn out to be something of a Pyrrhic victory. It's obviously going to be important to try and establish at an early stage, as is always the case in a family case, what the financial landscape looks like. And you're going to want to understand what the resources of the parties are. And again, I think it must be accepted that a holding of cryptocurrency is potentially a resource. And the fact that it is held by trustees or within a trust structure is not of itself going to be a complete end to that investigation. It's going to be, as is always the case with trusts and divorce, you're going to want to look at the terms of the trust and the circumstances in which it was set up. And particularly, you're going to want to understand whether it's possible to argue that you've got a nuptial settlement which is capable of being varied. If you've got a settlement which was, and the settlor was one of the parties to the marriage, he settled the cryptocurrency, and he and his wife and children are potential beneficiaries of that settlement, you're most likely going to have a trust which the English court can vary. And actually, you may well find that trying to vary the trust, I get an order at trust level, may be more effective than trying to get at the cryptocurrency which is held within the trust or the trust structure. Again, the English court has rather boldly said that it can make these variation orders in respect of trusts abroad. Again, I think Andreas may will talk about, if we've got time, the firewall legislation and the attitude of some of the offshore courts towards those exorbitant exercises of jurisdiction by the English courts. And of course, as Andreas has also mentioned, you could potentially be into the area where the trust has been set up with so wide reserve powers in favour of the settlor stroke beneficiary that questions are going to be asked, not whether it's a sham, but whether it's this wonderful creature of an illusory trust. Something, when is a trust not a trust type of argument, which amuses matrimonial lawyers, but in real and practical terms can make a big difference for claimant wives. But the final point is that, assuming you can't vary, assuming it is a valid trust, you may well be into a situation such as Mr. Sharman found himself in, where he had set up a trust during a marriage. He'd put a large amount of his wealth in that trust, but because of the way the letters of wishes were worded and the manner in which the trustees had exercised their discretions in his favour, there was no doubt that that was a resource available to him, and the English court simply made a very large lump sum order against him, knowing that he would need to go to the trustees, cap in hand, and ask for them to help bail him out.
Indeed, thank you. Should we come to Andreas now on the sort of Jersey enforcement side of things? How might matrimonial claims be enforced against the crypto assets held by Jersey trustees, and will Jersey's firewall legislation prevent enforcement, do you think?
Yeah, so the firewall is an important consideration in this, and it provides essentially that where a foreign judgment has been reached by applying a law other than Jersey law, it won't be enforceable in Jersey, and that's what prevents, if you like, orders of the family court being enforced in Jersey against trustees, because they will be applied. They will have applied English matrimonial law to vary a Jersey trust. But that's not particularly useful as a defense against enforcement if your assets, which the order is trying to get to, aren't located in Jersey. So a good example was the Otto Poon divorce, which took place in the Hong Kong Court of Final Appeal and concerned a Jersey law trust with a BVI trustee. And on the facts, the vast majority of the assets of that trust were located in Hong Kong and in the People's Republic of China. So the court, the matrimonial court, had more than enough assets to exercise its jurisdiction over without needing to trouble itself with what our firewall said. But so to try and determine where the crypto assets are, because that's what we're interested in, is actually very difficult. So it's been said of cryptocurrencies using distributed ledger technology that they're both everywhere and nowhere, because they're on the blockchain. Blockchain is maintained by computers in a dispersed network. So there's no one particular place that you can say that currency is located. So in practice, you would go about seeking to enforce against a crypto asset in much the same way as you would look to enforce against another asset. Is where is the practical control? So where are the private keys? Can you get to where the private keys are? So for example, if a trustee has been silly enough to leave the keys in the custody of the settlor, then you can of course enforce the court's order against the settlor, force them to hand over the private key, and if they don't, they could be committed. If the cryptocurrency is held by a custodian that is not in Jersey, then you can go to the jurisdiction where that custodian is and seek to enforce your order there under the local law if that's possible. And that local court isn't going to be applying Jersey law or firewall, that's for sure. And then further, if the cryptocurrency is held on an exchange rather than directly, then the court's order could be served on the exchange, much as my colleagues did. So a trustee might be interested in asking, are there any custodians in Jersey which you could use to try and mitigate against this risk of enforcement? And there is at least one that I've found, Komeinu, which is backed by Nomura, the Japanese investment bank, and it specializes in providing custody services to trustees and other institutions. There was a Jersey-based crypto exchange, but that is now shut. So I'm not aware that there would be a solution for keeping your assets within Jersey to protect against enforcement of such claims.
Thank you. That's very helpful. If I could come to you, Virginia, now as our resident tech expert on cryptocurrency, if I could introduce you in that way. What do we need to be aware of in terms of hacks and scams? So what do our trustee clients need to be aware of? What's going on in the market?
Hi, good afternoon. Thanks, Lucy. So following on from Andreas, the overriding risk with using cryptocurrencies as an asset or an investment from a practical perspective is that loss of the private wallet key. So that can be physically losing it, it can be losing control of it, or being forgotten. So cryptocurrency is stored in a digital anonymous wallet donated only by a long series of numbers and letters. And like John says, very much like a digital Swiss bank account. So the wallet is secured with a private digital key. And using the magic of prime numbers, that private key is almost impossible to break by just using digital brute force. So therefore, the weakness in that system lies in the humans who have to remember or store that wallet key. And most people do this, like Andreas mentioned, by maybe writing it down on a piece of paper or saving it as a file on their desktop. However, that exposes that private key to all of the normal security issues, whether that's a phishing email, a physical break-in, as well as all the conventional cybersecurity attacks. So the first question to always ask in order to ensure security of those assets is how that key is protected. Because ultimately, with cryptocurrencies, the person who controls that key controls the asset. So whichever way that key is stored, if lost, it's very, very difficult to recover those funds stored inside it. Globally, there's approximately 100 billion pounds of Bitcoin held in inaccessible wallets, encrypted by long forgotten keys. So from a wider perspective, there are some other risks and considerations when using cryptocurrency that have been in the press, about which people often express concern. So those are primarily exchange hacks, fraudulent initial coin offerings, and market manipulation. So firstly, the most popular way to buy cryptocurrency or exchange a cryptocurrency for a fiat currency is via an exchange, which is just a third-party app or a website which links your fiat bank account, like Barclays or Lloyd's, with your online cryptocurrency wallet. And they're ideal targets for hackers because they hold vast pools of client tokens in their control. So individuals will be taking a personal risk by placing their cryptocurrency into an exchange, which is vulnerable to a hack, since it's almost impossible for law enforcement to trace and recover those stolen funds. Both Bitcoin and Ethereum have suffered huge thefts, such as the infamous Japanese exchange Mt. Gox, which lost $500 million of Bitcoin a few years ago. And that had some quite far-reaching effects, including huge price fluctuations. And the cryptocurrency community was completely divided on how to actually deal with the aftermath of that hack. And then more recently, a Singapore-based exchange called KuCoin lost $280 million of Bitcoin and Ethereum last September, whereby hackers got hold of the private wallet keys of the exchange's online wallets holding client funds. So that anonymity of cryptocurrency makes those hackers very difficult to trace and the stolen funds very difficult to recover. So without the private keys to a digital wallet, those funds cannot easily be forcefully transferred or reclaimed in the same way as traditional bank accounts. So secondly, initial coin offerings are an integral part of the cryptocurrency ecosystem. And Andreas touched on them earlier as well. And it's just offering tokens in exchange for funding. But fraudulent ICOs are becoming increasingly common with these sham founders using false white papers. They attract investors and then disappear off with their money upon the completion of that ICO. There's also a lot of pump and dump ICO schemes whereby scammers will cash out after artificially driving up the prices, therefore leaving genuine investors with tokens of almost no value. A very famous example of this is a woman called Dr. Ruja, and she has been coined as the crypto queen. She launched supposedly Bitcoin's major rival called OneCoin. And it ended up having no substance, no blockchain behind it, but it had a wildly successful initial investment. And the founder, Dr. Ruja, ended up disappearing on the day of the conference, which launched OneCoin on exchanges, the day that the investors would have been able to exchange their OneCoin for fiat currency. And she disappeared with somewhere between 4 and 15 billion euros with her. So the third aspect would be the fraud within cryptocurrencies by market manipulation. So market manipulation is conducted by, they call them whales. They acquire enormous influence by owning large stakes of cryptocurrency, and they use their power to then employ classic market manipulation techniques like rinse and repeat and buy and sell walls. And then those whales cause the smaller investors to then panic sell or buy, and they fluctuate the market to their own advantage. So those techniques remain completely unregulated on the cryptocurrency market, despite their illegality on traditional markets. For example, the US government even previously flooded the Bitcoin market with thousands and thousands of confiscated Bitcoins and caused major price fluctuations.
So what would be your top tips for protecting yourself and your cryptocurrency?
So there are 4 key considerations in terms of protecting yourself. The first would be storing your private key safely. So depending on how that trust might be set up or arranged, the key may be held by the trustee, a law firm, a designated individual, or a crypto custodian. But regardless who's storing that, a protocol should be put in place in order to ensure that safe storage. A trustee shouldn't store the key digitally on their desktop, and also care should be taken about what sort of Wi-Fi's or internet portals those wallets are being accessed through. Public Wi-Fi's are very easy targets for data interception. Some people store their wallet key written down or encrypted into a graphic file. A great way I've heard of storing it is how people shard their keys by splitting that number across several different mediums and storage devices, and then only that person or group of people know how to put that code together in a certain way to reveal that key. So crypto custodians generally store keys in encrypted offline hard drives. And if you use a service like a crypto custodian, you will be relying on that third party taking sufficiently robust cybersecurity measures, but it may be a responsible step in fulfilling that fiduciary duty and could be easier than relying on a non-corporate trustee's own security. However, that control element does remain the same as with an exchange. So if you do relinquish custody of that key, you are no longer technically the controller of those funds. So that then goes on to pose questions about whether the trustee is maintaining sufficient control and protection to ensure that the validity of that trust. The second key consideration would be to properly store the funds. So once the cryptocurrency has been purchased and it's in the exchange, it's best to remove it and keep it in a cold storage wallet. So that is a wallet that is kept offline. So it's totally unconnected to the internet. They're usually stored on a USB drive or a similarly protected hard drive. That's not plugged into anything. So then when you do plug in that hard drive, you'll need to use your private wallet key in order to access those funds. So holding your cryptocurrency in an exchange for longer than necessary exposes you to two risks. The first is obviously the risk of theft if that exchange is hacked. And secondly, if that exchange becomes insolvent, you may not be able to recover your sums. So only keep the funds in the exchange wallet that you actually plan to trade. So for example, during that KuCoin hack I mentioned earlier, the cold storage wallets were completely unaffected by the hack because there was no way of accessing them because they were completely offline. There are also some secure online wallets with private keys, but distributing your cryptocurrency along several different wallets is a very practical way to minimize that risk. Thirdly, keeping your computer clean. So checking the address of the exchange before you log into a desktop. It sounds obvious, but there are lots and lots of phishing websites who visually exactly replicate those exchange platforms and have very similar URLs, and they're designed to steal that login and private key. And they're very, very common, and lots of people are taken in by them. So ensuring your computer is also not infected with any viruses or tracking software before making any transactions or logging into wallets or exchanges. And then finally, doing the due diligence on the exchanges that you're using. So the maturity of the exchange you're using is very important. So in order to check the history of data breaches or hacks, or better yet, diversify your investments across several different major exchanges and using traditional security techniques like two-factor authentication, and staying aware that when you do use an exchange, you lose physical control over those funds and entrust them to a third party. So remembering that the key holder is responsible for those assets, and even the most popular and seemingly trustworthy exchanges who do employ really rigorous safety precautions, such as Coinbase, they're not infallible, and private additional safety measures should always be taken in order to protect those assets.
Brilliant, thanks Virginia. Stuart, if I could come to you and to ask you, what are the key issues for trustees when thinking about their reputation when it comes to cryptocurrencies?
Thank you, Lucy, and hello, everyone. Well, in some ways, the questions that you need to ask yourself in terms of reputation in crypto are really no different, or not that much different, from those that you should be asking yourselves for other types of assets. So being best able to protect your reputation is really about challenging yourself before others do. So to do that, you need to have a good understanding of all the issues, many of which have been sort of talked about last week and this week as well, so that you can then make an assessment of the risks. And then think about where the challenge could come from. Now that's going to vary, of course, at least in part, from what type of organisation you are, what sort of trust you are, what sort of trustee you are, the position you hold, but mainly the questions come from the media. But questions could come from other areas as well. It could come from, I don't know, service users or donors or new trustees that come in. Or maybe if you have commercial relationships with government or something along those lines, then that could bring an extra set of pressures as well. So, but fundamentally, I think the challenge here is that many of those asking the questions won't understand the issues. So when you're trying to explain them, you're going to have to go back to the very beginning and be quite simplistic and quite straightforward, if you like, in your language, which again requires you to sort of have some understanding and take the advice to help you to do that. But yeah, again, as we saw last week and today, that's can be slightly easier said than done. But you also need to consider whether other aspects of your involvement in crypto, involve your reputation as well. In other words, are you sort of inflicting damage on your own reputation by being very much involved in crypto? So one obvious example, for instance, would be around, the implication around the environment. So if you're working for an organisation or a charity, for instance, does that chime with what your campaigning position is on climate change or energy? Do you take a strong ethical standpoint, which your holding might conflict with? In communications terms, we would say there's a sort of a say-do gap. So what you say and what you actually do, there's a slight difference, and that's where an outside organisation can drive a wedge, the media can drive a wedge, politicians can drive a wedge, and that's where the reputational damage can find itself. But equally, if you're a charity and you're campaigning, for instance, around, say, a famine issue or something like that, now that might not be, an obvious environmental issue, although it may well be. But if that famine is linked to climate change disasters, then again, holding your crypto is if you inflicting your own damage. So, and issues around transparency as well. More organisations nowadays pride themselves on their transparency. Does crypto lend itself to there? So there's a couple of sort of a couple there, Lucy, I think, to focus on initially anyway.
No, absolutely. Thank you. And in terms of practical considerations for actually managing your reputation, would you have any tips there? Well,
I think, a paperwork trail is always the best place to start, just showing that you've thought about these things. And funny enough, when Virginia was talking about, apart from the splitting of the cryptocurrency, which sort of reminded me of Horcruxes and Harry Potter and things like that, but the security side of things, it's all very well and good, having thinking about security, but actually, if you're not training your staff on security issues so they fall for the hack, then that will inflict the damage. So it's the paperwork trail to show you're working. So, and damage to reputations is often done when organizations simply haven't done anything or have ignored an issue, too difficult, or we'll deal with that later. So show that decision-making process so that you can demonstrate that you've balanced the requirements, the risks and the potential benefits, of which there will always be in all issues. And then think about responsibilities as well. The who is doing what, the protections that are put in place. So the early warning systems, if something goes wrong, do you think you have too much power in the hands of one person? For instance, the telltale signs that instinctively, risk-wise, you would be concerned about. And I think also, just especially at this very early stage, and this is going to sound slightly self-serving, but I think it's absolutely imperative, is just to get the right advice, because this is an area that we're all working through to one extent or another. And if you try and go out and go there on your own or go alone, it's much too easy to make mistakes. Whereas, take the sort of collective waters and take the advice that's open to you. And certainly, I've chatted to some of the specialist charities team here that we have here at BDB Pitmans, and one of those other things that we need to be incredibly careful at, particularly at the moment in these early stages, are the sources of finance as well. So there may be different questions if you're investing in cryptocurrency as opposed to receiving cryptocurrency. so so if you're a charity, obviously you have a choice about whether to receive funds, but what reassurance can you get about the provenance of those funds? Again, same sorts of questions as I mentioned earlier on that you would go under with more traditional assets, but the same with this as well. So track the origin as much as you can. Yeah, you can do that bit, but you can't see the holder, and critically, you can't see the source of the funds. So that may, though, for some people, be quite good if they want to donate to a charity, for instance, that maybe deals with quite a controversial issue. That might be a good thing. It doesn't necessarily per se mean that it's bad. So so think about the risks, manage those risks, have the paper trail, take the advice. I think that at this stage would be the best things to do.
Brilliant, thanks. How else could reputations run into trouble on this issue, do you think?
I think mainly because it's a fast-moving landscape, and I think because too many people don't really understand it. So that means training, keeping people up to date, all of those, regularly reviewing the policies and the positions and the paperwork trail. I think that's particularly important now.
Yeah.
I'd maintain a constant watch on things, and I'd learn from others as well. I'd learn from other trusts, other advice being given to others, and and keep up to date with that. But I think in particular, again, because of the fast changing nature, and we will see problems that arise invariably, we just will, then you tend to find the media get more involved and politicians get more involved. So the rules and the regulations and the general level of interference, if I can put it in that way, tend to rise. So I think, again, in those sorts of issues, if you're keeping up to date, if you're keeping a constant watch, you're going to be in a good position. If you have the decision, put it to one side and leave it, that's where you'll get into problems because of this intervention. I think we will see more and more of.
Thanks, Stuart. Really helpful tips there. So just looking at the questions, we do have time for questions, and we just have one question, but it's a very good question, if I may say so. How do trustees get themselves familiar with the unregulated and relatively new crypto market? And aside from any legal risk, is holding this type of asset, given its perceived risks, likely to place a trustee under greater regulatory scrutiny? Yeah, a really key question. Thank you for that. Who would like to answer that? Andreas and John, any comments to offer?
I can start with some thoughts, and then grateful
Thank
if
you.
John can help out as well. So I think the starting point has to be do your research, essentially. Given the nature of the asset in particular, there's a huge wealth of information on the internet about how these currencies work, the theories behind them. There's obviously the horror stories of what's gone wrong. And I think reading the horror stories also educates you about exactly what the nature of this asset is and what the risks are. You could attend presentations like this one, of course. You can also, of course, dip your toe in the water. So start small and build your experience, investing a very small proportion of trust funds, so that if something is lost, then you can at least build on that knowledge and you can justify yourself to your beneficiaries that you haven't taken an undue risk with the investment. On the question about regulatory scrutiny, I think that's an excellent question. And I think that the regulators, they'll take different approaches in every jurisdiction, I'm sure. But the sort of thing that I would expect would exercise them would be if a trustee is taking an irresponsible approach, if they are building up excessive risk on the balance sheets of the trusts that they administer, if they're not sufficiently diversifying away from the risk of crypto so that it exposes the trust fund to serious loss. The absence of advice, so the corollary of the first point, if you can't show you've taken advice and educated yourself about what you're investing in, that's not going to be a good look at all. Of course, if you do suffer a significant loss, and in particular, if that results in a beneficiary complaint to the regulator, that's going to invite some scrutiny. And then the other major one, of course, dealing with the nature of the asset, is tainted funds. So if you as a beneficiary end up with cryptocurrency, which does turn out to have come from an illegitimate source, the question that can happen to any trustee. the question from the regulator is going to be, what are your anti-money laundering processes like in respect of these specific assets, and designing to protect against the risk of dealing with tainted funds.
Thank you. Anybody else, anything to add?
Well, I mean, I agree with all that Andreas has said. I think from a practical point of view, I suppose there are two things that leap to the forefront of one's mind. The first is cost. We are in an industry where lots of clients and settlors and beneficiaries are constantly looking at the figures to make sure that the costs of setting up a structure, the cost of maintaining and managing the structure are not seen by them to be disproportionate or out of kilter. And I think so often that the desire to keep costs down can often be a hostage to fortune. I think this is one of those areas where doing it well at the outset will really bring dividends in the future. And I think Chris was talking about this last week, which was it's so much easier to deal with an investment such as cryptocurrency with a new structure specifically designed to deal with it than to try and bolt it on or into an existing structure simply because a settlor thinks that's the cheapest and easiest way to go. And the second point is I don't think this is in any way specific to cryptocurrency, but ignorance, an unwillingness or a desire not to find out what you're actually dealing with, but on the contrary to keep the envelope closed and not look at it, regardless of whether you've got an anti-Bartlett clause which is effective, is probably going to cause problems down the line.
Absolutely. Thanks, John. Well, just remains really for me to thank.
I was just going to...
Oh, sorry, you're going to go, Stuart.
No. All I was going to very quickly say, apologies for cutting across you. I thought I was going to say was sources of information, membership bodies, trade bodies, representative bodies, those sorts of organisations doing lots of good work, trying to keep up to date with these sorts of things. So, and your general networks will be fantastic because others will be in a very similar position. So just talk and learn from them. And I think that. I think the question or the key word is scrutiny, because I think that scrutiny will come from a range of different organisations. So it's not just sort of legal and regulatory, but media, social media, and others that you deal with on a day-to-day basis. So if you get involved, scrutiny will go up, I think, across the piece.
Brilliant. Well, thank you to each of you on our panel today. We hope that you've found it an informative, lively, thought-provoking session again. Thank you all very much for attending. I'm sure our panelists would be happy to take any questions after by email or phone if you wish to raise any further points. But thanks very much for attending, everybody. Goodbye.
Thank you.